Hello everyone, I'm Abasul and welcome to my today's session, which is a continuation of last day's session on the topic of legal issues, contract, and electronic discovery. So in last session, we have discussed till data retention law and record keeping obligations. So in this session, we will be covering the rest of the topic. So let's start with the collection. So, because of the potential lack of administrative controls a client has over its data in the cloud, collection from cloud can be more difficult, more time consuming, and more expensive than from behind a client's firewall. In particular, a client may not have same level of visibility across its cloud data. It may have more difficulty comparing the it has collected with the data in cloud to determine the export was reasonably complete and accurate. So what we have inside that first is access and uh, bandwidth. In most cases, a client access to its data in the cloud will be determined by its SLAs. This may limit its ability to collect large volume of data quickly and in forensically sound manner. Client and cloud providers should consider this issue at the outset of their relationship and establish a protocol for extraordinary access in the case of litigations. Absent these agreements, clients are responsible for extra time, cost implication by collection in the cloud when making representations to requesting parties and codes. Next is forensics. Bit by bit image of a cloud data sources is generally difficult or impossible. For obvious security reasons, providers are reluctant to allow access to their hardware, particularly in multi-tenant environments where a client could gain an access to other clients' data. Even the private cloud forensic may be extremely difficult, and the client may need to notify opposing counsel or court for these limitation. Luckily, these type of forensic analysis is really warranted in cloud computing because the environment often consists of a structured data hierarchy or virtualization that does not provide significant additional information. Next is reasonable integrity. A client subject to a discovery request should undertake reasonable steps to validate that its collection from its cloud provider is complete and accurate, especially where ordinary business produce for the request of unavailable and litigation specific measures are being used to obtain the information. And the next is limit to accessibility due to the difference in how data is stored and the access right and privileges available to owner of the data. There are cases where a cloud customer may not be able to access all their data stored in the cloud. The cloud customer and cloud provider may have to analyze the request for information and pertinent data structure for relevance, materiality, proposition, and accessibility. The next is direct access. Outside the cloud environment, a requesting party direct access to responding to parties IT environment is not generally favored. It does not happen from time to time. In fact, some courts have been willing to allow no notice seize of IT equipment for the purpose of evidence preservation in civil cases, including employment disputes. In cloud environment, it is even less favored and may be impossible as a forensic analysis but may be impossible. Some cloud providers may not be able to provide direct access because the hardware and facility are outside the possession, custody, and control. The next is the native production. Cloud service provider often stores data in a highly proprietary system and application that clients does not control. Eventually, ESI is expected to be produced in standard formats such as PDFs for electronic document unless information lost by conversion is relevant to the dispute. Data in its cloud native format may be useless to the requesting party. In these circumstances, it may be best for all concerned requesting party, producing party, and provider that the relevant information be exported using standard protocol within cloud environment. Next is authentication. Authentication in this text is referring to the forensic authentication of the data emitted into evidence. This should not be confused with the user authentication, which is a component of identity management. Storing data in the cloud does not affect the authentication of data to determine if it should be admitted into evidence. The question is whether the document is what is purported to be. For example, an email is no more or less authentic because it was stored behind a company's firewall or was stored in the cloud. Next is corporate between provider and the client in e-discovery. It is in the best interest for both provider and the client to consider the complication causing by the discovery at the beginning of their relationship and to account for it in their SLAs. Provider may want to consider designing their cloud offering to include discovery services to attract clients. In any event, clients and providers should consider including an agreement to reasonably cooperate with each other in the event of discovery request against each other. And the last topic is respond to subpoena or search warrant. Should a cloud service provider receive from a third party a request to provide the information, this may be in the form of subpoena, a warrant, or a court order in which access to the client data is demanded. The client may want to have the ability to fight the request for access in order to protect the confidentiality of their data. To this end, the cloud service agreement should require the cloud service provider to notify the customer that Symphony was received and give the company time to fight the request for access. So this is what we are having in the topic of electronic discovery. Thank you.